8. We'll just check in, make sure everybody's present. We have Mr. Levitt representing Crystal Floric. Mr. Levitt, can you hear me okay?
Yes, I can. Thank you.
Okay, great. Ms. Powers represents David Floric. Ms. Powers, are you here?
I am, Your Honor.
Okay, welcome. And let's double check. Okay. Let's see. We are here this morning on Mr. Floric's motion to set aside the February 15th order of default as to the abatement of child support. And there's a later in time, if that motion is granted, a later in time motion to modify child support. So I read the pleadings that the parties submitted, including the packet that Mr. Levitt filed and had provided working copies, and I reviewed all the documents that Mr. Floric also submitted. So, Ms. Powers, this is your motion, so I'll hear from you, please.
Thank you. Before we proceed, can the court inquire if Mr. Floric is present? I filled out the paperwork with DOC and had it coordinated for him to be present today.
Yeah, let's double check. David Floric, if you're on the line, please unmute and state your name. David Floric. Kind of just looking at my Zoom screen, see if I can.
I know that he was planning to call in through the Zoom number, but I assume he'd still appear as a name or someone we could see.
Yeah, yeah, that's true. Either, okay, hold on a second. Got a couple other folks that are waiting to be admitted, so let me get them in. And one includes a phone number. So I'll ask if David Floric, if you're on the line, will you please state your name?
This is Counselor Fisher for David Floric. I'm going to need to transfer him to the transfer this call to the phone. Can you bear with me momentarily?
Sure.
Okay, 1 minute.
I'm almost positive if we decide to go to a different case, then he'll come right on the line as soon as we move to that next case.
David Floric.
Okay, Mr. Floric, I'm Judge Evans. We're here on the self-represented family law docket. On the line with us, we have Mr. Levitt, who represents Crystal Floric. Mr. Floric is present also. Ms. Powers, your attorney, is on the line. We're here for a motion related to, it's your motion to set aside a February 15 order related to abatement of child support. So I'll turn the time to Ms. Powers.
Thank you, Your Honor. As the court's aware, there was a hearing held on February 14th regarding the issue of abatement. My client was not present at that hearing. We've submitted information to the court that he had tried to appear. When Mr. Floric first retained me, we had a pretty short turnaround on this motion. My understanding at that point was that he had tried to log into Zoom and was unsuccessful. What has become clear since then and is reflected in the communications that Ms. Floric submitted to the court in her response is that Mr. Floric communicated with his officer the day of the hearing, trying to appear at the hearing. It was not the correct procedure to appear, and so he was not given the opportunity to try to appear. So that is why he was not there on February 14th. We're asking that the court give us a new hearing so that we can present the evidence that we have so that the court can have complete information in making the decision about whether or not an abatement is appropriate in this situation. In our initial motion, we asked that if the court granted this motion and set another hearing, that it be out 30 days. Since this hearing ended up getting set out, I've been able to prepare all of our responsive pleadings and have already filed them with the court. So we would be prepared to go forward on the full abatement hearing at any time. We just ask that the court give us another shot. I recognize Mr. Floric should have filed something in writing, but he did not. He thought he could appear. The procedure for appearing was more difficult than anticipated. As you can see in the emails provided by the legal liaison for the prison requires something in writing from the court or from an attorney in order to set up the appearance. He did not have an attorney at that point and did not receive communication right from the court in order to get that set up. I jumped through those hoops so Mr. Floric is able to be here and participate today. We would just ask for a new hearing so that his side can be heard in this decision.
Thank you, Ms. Powers. Mr. Levitt.
Thank you, Your Honor. First, I have to object to the form of this motion. This was filed as a CR 59 motion. CR 59 has to do with the court reconsidering prior decisions or getting relief or setting a new trial. There has been no trial in this matter. Rather, this should have been set pursuant to Civil Rule 60, which is motions to vacate, and that appears to be what Mr. Florek is seeking, is basically a do-over for the hearing that he did not attend, or the hearings, plural, that he did not attend. With regard to the difference in the two motions, I think a Civil Rule 60 motion requires respondent to first show cause the motion and have the court preliminarily review it in order to set the hearing. That was not done in this case, and I don't think it is appropriate to be granted here. Second, there is established case law in Civil Rule 60 that I could cite to in brief, but when it comes to CR 59, there's very limited case law on motions to vacate under CR 59 because that's not the appropriate civil rule. I drew this to counsel's attention, and she confirmed that she intended to argue a motion to vacate under CR 59. So I don't think that it's appropriately before the court, number one. Number two, it's also inappropriate before the court because none of the pleadings have been signed by Mr. Florek. I understand that he's incarcerated, but his father does not have the underlying knowledge necessary to sign on his son's behalf. So all of David Florek's documentation under penalty of perjury is hearsay because it was not signed by him. Finally, when we get to the underlying motion itself, the basis or proclaimed basis is that there were some irregularities in the procedure, and respondent is basically saying there was an error with Zoom, I couldn't attend. And then when we show that he actually didn't make any efforts to attend until maybe it was too late for the second hearing, because this was before the court at least 2 times, that it was too little too late and he was unable to attend. Finally, abatement is appropriate when incarcerated persons have no access to funds because their income is stopped by reason of them being in jail. In this case, respondent has significant access to funds and has stated through his father that he doesn't want to have to pay child support so that he can support himself when he is eventually released from incarceration. That is not a reason to undo the order. So I would ask that the court pay attention to respondents' priorities here. And this is similar to a situation where the obligor parent is refusing to pay child support because they say they have too many expenses, but they have the ability to pay and are choosing to support themselves over their children. Here, respondent is choosing to save for when he is eventually released. Has $80,000 in the bank right now. He just doesn't want to use it to support the children. So I would ask that this motion be denied. I would ask that respondent be ordered to pay some amount in attorney fees for having to be here on this improper motion, and that just that it be denied, that should be granted some award of attorney fees, and then we'll be here, I believe, next month on the petition to modify child support. Does Your Honor have any questions for me or my client?
One question for you, Mr. Levitt. I was looking at CR 59, and I was taking a look at there's some conjunctions or ors in there. It says, on the motion of the party aggrieved, it says a verdict may be vacated and a new trial granted to any and all the parties on all the issues, or on some of the issues, or any other decision or order may be vacated and reconsideration granted. So what's your take on that language as opposed to CR 60? And then what's your take on what's the remedy for if it is under the wrong rule? What's your remedy?
Well, the remedy would be to require the respondent to refile this as a CR 60 motion to vacate. I understand that there is probably some room in CR 59 to maybe allow a motion under this civil rule, but there is very limited case law that I can point to be able to actually argue for it. Instead, CR 60 is clearly on point. It clearly says this is the procedure, and there's significant case law pointing out these are the circumstances under which orders can be vacated or orders should be vacated. Whereas CR 59 is primarily focused on granting a new trial or a verdict. We don't have any of those in this case. And motions for reconsideration, which again, that is not what we are before the court for right now.
CR 59 has a 10-day rule related to once a judgment or a verdict has been entered, then there needs to be a motion filed within 10 days of that. And was that met here?
I would have to, well, let me look at my pleading index that my support staff was so kind to do for me. We've got the order terminating the abatement from February 15th, and then the motion to set aside was filed on February 23rd. However, it wasn't served, I believe, until after the 10 days had passed. Also, there was a declaration of mailing, but my client never received those documents. So I don't know if it was actually mailed or if they got the wrong address. But we appeared, we are here and ready to move forward on the motion. I just don't think it's the appropriate way to do so.
Thank you, Mr. Levitt. Ms. Powers?
Thank you, Your Honor.
Thank you, Your Honor. Just briefly in reply, I do believe that a CR 59 motion is appropriate here. We did file it within the 10 days that were required. And as you cited under Section A of the rule, it says any other decision or order may be vacated and reconsideration granted. So we're asking that it be set aside and a new hearing be granted on this issue. We did mail it to Ms. Florek the same day that it was filed. We filed our affidavit of mailing with the court. We sent it to the address that Ms. Florek had provided on her pleadings. It was never returned to us. Ms. Florek did retain an attorney, so service was proper on the motion. I wanted to just briefly talk to Mr. Levitt. Indicates that it was inappropriate for David Florek's father to sign the declaration. The declaration that we submitted signed by Mr. Florek's father is for the hearing if the court grants an abatement. The initial motion, I signed an affirmation of counsel based on the information that was given me at that time because there was not any time to mail things to Mr. Florek in prison and get his signature back. In the 2 months that I've been on this case, it has been significantly difficult to communicate with Mr. Florek and to get documents back from him. For the declaration that James Florek signed as power of attorney for David, I had emailed David Florek the declaration, had him review it, got his okay, and then had his father sign. I can tell you as an officer of the court that I emailed it through the court ocurrs email system, and because it was a lengthy email, it didn't get to David for at least a week. So there was a delay there. I have also mailed him a few different things from our office following the prison protocol, and both times it has been returned to my office and had to be remailed to him. And so Mr. James Florek has power of attorney. David approved the document and James signed on his behalf. I don't think that that was inappropriate in this situation or given the power that James has under the power of attorney. Lastly, Mr. Levitt asked for attorney fees. I'd ask that the court deny that. My client filed an appropriate motion and we're asking for relief, and he should not have to pay attorney fees for doing that.
All right, thank you, Ms. Powers. Okay, as to Mr. Levitt's first argument related to CR 60 versus CR 59, I think there's probably room for both matters to be brought under either. CR 59 does talk about new trials and verdicts and the like, but then the idea behind both of those rules is that any dispute is desired or preferred to be resolved on its merits. And if there's any irregularities, that basically there needs to be a fair hearing, kind of a fair playing ground for everybody to play in. So Mr. Levitt points to the fact that Mr. Florek failed to provide any type of written response to the motion and relied upon simply trying to get on via Zoom and just make an oral or verbal, which is allowable, but especially under pro se circumstances. There's also, it's noted that Ms. Powers indicates that an individual who's incarcerated can't just put themselves on a Zoom call. It has to be either from the court or an attorney making that request. So here, I think that there's enough of the difficulties that occur when a person's incarcerated to set aside that verdict of, or that order from February 14th or 15th, and to have the case heard on its merits. I am going to award attorney fees of $500 that Mr. Florek will need to pay to Ms. Florek. So based on that, I'll grant that motion. And then Ms. Powers, if you would kindly circulate a proposed order and have Mr. Levitt look at it, and then we can review it when we come back for the next hearing on the motion to modify.
We filed a petition to modify, but I feel that that's a separate issue from the abatement. I would ask the court to set a hearing on the abatement issue itself.
Okay. Do you have some proposed timeframes?
I've already filed.
For the purposes of judicial economy and frankly reduced attorney fees costs, I would ask that we appear on both the motion and the petition to modify on May 21st, 2024.
Thank you. Ms. Powers?
That would be fine with me.
Okay. Let's combine both on that day. So May 21 will be the date where we hear both the issues related to the abatement and also the issues related to the petition to modify.
And once I've circulated an order, can I send that electronically to the court, or do you want to set a date for presentation?
Mr. Levitt, any preference on your end?
I believe counsel and I could get it done. I understand the abatement, or the court is allowing a hearing. Hearing's going to go forward at the time that we already have a motion noted. $500 attorney fees is awarded, and we'll take up the rest on May 21st, I believe.
Okay, yeah, that sounds fine. As far as the proposed order from today's hearing, electronic submission would be fine, and then I can sign off on it.
Okay, and the May 21st is on the attorney docket on a Tuesday. Does the court care if it's not in front of you, or do you want it all moved in front of you?
I think with the fact that there's two attorneys present, it would be proper to place it on the represented or attorney docket, and that's the one that's been noted for the 1 p.m. on the 21st.
It is.
Okay. Yeah, I think that would be preferable. So we'll keep it on that date.
Thank you.
Okay. All right. Thank you both. Any final issues?
No, Your Honor. Thank you.
Okay. That is Mr. Zandy. You're representing Jonathan Walker. Mr. Zandy. And I'll ask if Ms. Boaglio, if she's present. Nicole Boaglio, are you on the line? All right, Ms. Boaglio, if you are speaking, I can't hear you. So please make sure you're unmuted. And again, just state your name, please. All right, and just double checking the Zoom log here under Nicole, either Walker or Boaglio, to see if she's present. Not seeing any indication that she is on the Zoom call, so it looks like she's not here. This is her motion. Without her being present, I'll hear from Mr. Zandy.
Yeah, I'm surprised she's not, Judge, but nonetheless, I'm very new to this case. I reviewed the file prior to this morning's docket. Looks like service was a little bit late. My client was never served until March 27th, which is about 7 days short of the hearing as required by the local rule. I was going to ask that this be set over. Given the fact she's not here, I don't know if the court is more appropriate to strike that. I can tell you that we filed our own motion, which is set for May 14th on the attorney docket to get some clarity on a GAL appointment and a mandatory settlement conference, which is later next month as well. So I'm fine if we consolidate everything into that May 14th docket, or alternatively strike the hearing today, depending on what the court deems appropriate.
Thanks, Mr. Zandy. I think what I'd like to do is just note that Ms. Boaglio is not present today, and then move everything to that date that you mentioned, May 14th, on the attorney docket. So let's move this motion, set it on that docket, and if hopefully she can be here on that date and we can address the issue.
Very well. Thank you.
That case earlier and nobody was present, but I think both parties may be on the line now. So I'll ask if Cameron Miller, if you're on the line, if state your name, please. All right, maybe they're not. Taylor Young, if you're on the line, state your name, please. Okay, looks like they're not here. All right. Okay. All right. Thank you. Just a moment.
I represent Ms. Ellsworth.
Okay. And then did you file a notice of appearance?
Yes, we did yesterday, so it should be in the file. I'm not sure if it's coming up yet for you to see.
All right, very good. So you, Ms. Poplowski, you're representing Ms. Ellsworth, and I'll ask if Anthony Cooper is on the line. Anthony Cooper, are you here today? Anthony Cooper, if you're here, make sure you're unmuted and state your name.
Yes, I'm here, Anthony Cooper.
There you are. Okay, thanks, Mr. Cooper. All right, so Mr. Cooper, I show that we're on today for, looks like your motion for payment of costs. And I'll double check with Ms. Poplowski. Is that your understanding of why we're here today?
Yes, Your Honor. I believe there was some misfilings of the way he filed before adequate cause or something, but I believe it's for he wants payment of fees.
Okay, that's my understanding also. Double checking with you, Mr. Cooper, is that your understanding of why we're here this morning is on your motion for payment of costs or fees?
Yes. So today I'm asking the courts to side with me and to charge Ms. Ellsworth with payment of costs. I'm asking to be reimbursed up to 40 hours of missed work, as well as for her to pay any attorney fees I had required from the case before. Now, the reason why I feel this is fair is because Ms. Ellsworth has a history of taking me to court for unnecessary reasons. Our most recent case that we have regarding the parenting plan was filed and signed into law. We were both we're known that...
Your sound dropped off. I can't hear you anymore.
Oh, I'm sorry. Can you hear me now?
Yes.
Okay. So when the last parenting plan was signed into law, we were both known that this was supposed to be the end all to be all of parenting plans. Unless something drastic happens to me, or unless I want to change the parenting plan, there should be no reason why we would have to go back to court for any disputes. Ms. Ellsworth was already held into contempt for the second time, and not even 2 years later, here we are again.
Thank you, Mr. Cooper. Can I ask you a question?
Yes, sir.
You're asking for 40 hours of missed work. Have you broken that down? Have you submitted a declaration for the court to see and understand of what dates and what times?
I've broken it down, but I have not made a declaration. No. Okay.
And then you mentioned you're asking for attorney fees in the case before. When you said the case before, I was a little bit unclear what that means.
For the parenting plan case, the one where that spurred me to do the payment of costs in the first place.
Okay.
Let me see. Do you need the number, or
is it a different number than the 163556-4?
No, it's the same one.
Same one. Okay. And then how long ago did you pay those attorney fees?
I haven't finished them up yet.
How long ago did you incur those fees?
Oh, since the beginning of March
of this year.
Yes.
And how did you submit any declaration as to the amount?
Not yet. No.
Okay. All right. Okay. Anything else, Mr. Cooper?
No, that's all.
Okay. Thank you. Ms. Poplowski?
Thank you, Your Honor. May it please the court, Ms. Ellsworth and Mr. Cooper. Your Honor, I think the court had it just right when the court asked if there was anything to break down what these costs are. I don't think you get to come to court, particularly under 2609-140, which really talks about that the court, after considering the financial resources of both parties, may order a party to pay a reasonable amount of fees for maintaining or defending a proceeding under this chapter. First of all, it has to be where you're actually telling the court what you incurred. To say, well, I incurred fees because of contempts that were in 2018 and 2019. Here we are, 2024. Also keep in mind that my client was ordered to pay fees of $22, $50, and $100 civil penalty. So the court already made a determination regarding those contempts, whether or not she was required to pay fees. Whether she pays them or not, that's something for another day, a judgment against her, and she she has to suffer the consequences of that. I don't think 5, 6 years later, you get to come back to court and say, now I want more fees on top of that. The court at that time made that decision as to what was appropriate. The same thing happens when you come to court on any other action. I'm looking at the other prior orders, and I don't see any findings that indicate anything about attorney fees. I don't see any findings or any order that says Mr. Cooper has the right to come back for fees because these proceedings were unnecessary. I don't see anything at all. He wants her to pay attorney fees, but yet there's no bills from any attorney fees. There's no attorney fee affidavit. There's nothing about it being incurred. I tried to look through the file, and it looks like the last time there was an attorney on board was 2019. So I'm unsure why Mr. Cooper is saying he has attorney fees that he's incurred just this past March. There's no attorney on board here. I don't see a notice of appearance for any attorney. So I don't know what attorney fees there would be. To just also then say flat out, I want her to pay 40 hours of my work. 40 hours for what? How is that broken down? What time did you take off? Was it related to the contempts? What was it related to that the court can make that sort of determination? And I also think those determinations, Your Honor, should have been made at the time of those proceedings, where that judicial officer can determine, is this appropriate? Isn't it appropriate? Does she have a right to be here? Doesn't she? Was this a frivolous action? Not. For Mr. Cooper to come to say, that we were informed that this was the end-all, be-all to a parenting plan unless he wants to change it. That's not what the law says. Each party has a right under the law to come to court to modify if they meet the criteria for that. Did Ms. Ellsworth come to court and was she denied adequate cause? That is true. But the court at that time had the right to order fees, and the court didn't do that. And there were no findings in there relative to any sort of frivolous action. Did she bring it and the court determined it wasn't adequate cause? That's true. It doesn't mean that it was frivolous. And it doesn't mean that in 6 years, if she was found in contempt and then she came to court on a modification, that she did anything wrong. I ask that you deny those fees. And furthermore, Your Honor, I think that Mr. Cooper has to come to court with at minimum a financial declaration to also show his financial resources and his circumstances, because that's what 2609-140 says, and he hasn't done that either. Thank you.
Thank you, Ms. Poplowski. Mr. Cooper, any response?
Okay, so I don't know, maybe I misheard. I'm not asking for her to be reimbursed from the years prior. I'm simply asking to be reimbursed now. I understand from this last case, I have all of my stuff written down, but I just not haven't sent it over yet. I will file another declaration for that. But the only reason why I feel this whole thing is unnecessary, I don't know the law too much. So when the lawyer says that she can go into court and just bring me to court anytime Miss Ellsworth feels like it to try to change the plan, to me, it's unnecessary because I have to miss work in order to do these things.
All right. Thank you, Mr. Cooper. All right. So anytime a court makes a decision, there needs to be a factual basis upon which a decision is based. Here, Mr. Cooper is making a request for attorney fees for missed work of 40 hours and attorney costs or attorney fees. But absent is the declaration or a factual basis or a foundation which would allow me to make a decision on that. So I don't have that requisite factual basis to move forward. Also, it's important to know also that generally, these types of motions are best heard at the time of or in close proximity to the actual hearing. That allows the judicial officer to make a determination based on all those relevant factors that are happening at that time, what would be an appropriate amount. Some may say that the motion is stale if you're going back really far, but it sounds like you're not going back super far, Mr. Cooper. But that's kind of the idea, is that there is an opportunity at that time of the hearing to make a request for costs under 2609-140. I think it was the statute that you cited, which allows for that. So without the requisite factual foundation or declaration supporting a breakdown of how many hours on what day, hourly wage, or what the dollar amounts that missed from work for being in a particular court hearing, and without information regarding the attorney fees, I'm going to deny the motion, and I'll just do a bench order to that effect, denying the motion. So I'll ask the parties if they have any question. Mr. Cooper, any questions?
No, Your Honor.
All right, Ms. Poplowski.
No, Your Honor.
All right, I will draft that order. It should be in the file no later than Friday of this week. So if you need a copy, you can look shortly thereafter for it. Okay. Yes, all right. That'll conclude today's matter. Thank you.
Unfortunately, number 8, O'Brien and James, I have not yet completed that report. My own fault. And would like a couple more weeks on that if possible.
Okay. Let's make sure everybody's here on that matter. So if they have input on that. So Monique O'Brien, are you here today? Monique O'Brien?
I'm here.
Okay. Welcome to you, Ms. O'Brien. And then I'll ask if Brandon James, if you're on the line.
Yes, Your Honor.
Okay. Welcome to both of you. Were you able to hear Ms. Corey's request? She was asking that the matter be set over. Was it 1 week, Ms. Corey?
2 would be ideal so that I could get it to the parties to review before we appear again.
Okay. So the 24th is full at this point. So we'd either be looking at the week after, which would be May 1st.
May 1st.
Yeah. What is your take on that, Ms. O'Brien? There's a request that this hearing just be set over so Ms. Corey can submit her report and you all can look at it and come to court prepared.
May 1st would work best for me if we're going to do that.
Okay. And Mr. James?
Yeah, that works.
Okay. We'll set the matter over to May 1st. That'll allow Ms. Corey to finalize her report, distribute it to the parties, and then we'll review it on that date.
Thank you.
Thank you, Your Honor.
We'll say everybody's on the case. Last name is Burchett. So I'll ask if Brittany Buchanan, are you on the line today?
I am.
Okay, welcome to you. And Jeremy Floyd, are you on the line today? Jeremy Floyd, if you're here today, if you'd please unmute and state your name. I'm just looking at the Zoom participant list, not seeing a name that is remotely close to that. Let me touch base with Ms. Buchanan. Ms. Buchanan, when I looked over over the file, what I saw is that we're here today for your motion on adequate cause to modify a parenting plan. One thing that to keep a note with that type of petition, there's a summons that is part of the case, and you file that summons. What I was looking for is whether there was service of that summons other than certified mail. What I saw is that there was certified mail sent to 1935 First Avenue, which is the Cowlitz County Jail, and that it was received at that location. Under RCW 428-080 sub 16 and also sub 17 says that the person needs to be served personally or leaving a copy of the summons at the house or their usual abode with some person of suitable age and discretion or a resident therein. So what I'm not seeing is that. So other than sending the summons via certified mail to Mr. Floyd, was there any other means or attempts of service?
No.
Okay. All right. So that's a prerequisite. It may seem kind of problematic or silly, even if you will, to require that, but that's what the rules require is that personal service of a summons. So I don't have anything that the jail says that these documents were given directly to Mr. Floyd. I have a certified document that says they were received at the jail, and so that's insufficient as far as notice. So Ms. Buchanan, I apologize. We won't be able to go forward today with your motion. That summons has to be properly served.
Okay.
So we'll strike the matter for today, and then you can give it a go if you're still interested in that motion, which I assume you are. You made the effort to go what you did so far. So yeah. We'll strike the matter. My apologies, and then we'll just come back on a day when the service is there, and we can proceed and have the matter heard.
Okay, so my only question, I guess, is there anything other than proving of personal service that has to be done for this to go forward?
Well, the law does take into account the fact that sometimes it's very difficult to find people. And if there's sometimes people want one option that people will explore if they've had difficulty finding somebody is a motion to publish or a publication service by publication. There's some certain steps that you need to follow in order to get that. Basically, you have to get approval from the court to publish something or serve by publication. So that's one option. Another option, which you may already be familiar with, is WashingtonLawHelp.org. It's a website. That's one option that you could look at. They have forms. They also have a lot of explanation of different processes. So you can check there. Another option would be the CLEAR hotline, CLEAR, CLEAR hotline. You can just look that up on on a search engine. It'll pop right up. It's staffed by attorneys. Does have limited hours, but those are two options that you can explore related to service.
Okay.
All right. Okay. We'll see you when we see you. Thanks.
Lakey's on the line. I'll be back. Thanks.
Yes, I am, Your Honor.
Okay. Welcome to you, Ms. Lakey. I'll ask if Kenton Lakey is on the line.
Yes, I am, Your Honor. Thank you.
Okay. Welcome to Mr. Lakey. And I see Ms. Turnbull is also present. Let's see. And I apologize. I should be calling Ms. Lakey Ms. Jones. So sorry for that. So we have Ms. Jones present, and we have Mr. Lakey present, and we have Ms. Turnbull present. Okay. Let me just pull up my notes, and then we'll go ahead and get started. Okay, so this is Ms. Turnbull submitted a report on a parenting plan and her views on that, and I'll just double check with each party to ensure that you received a copy of that document. Ms. Jones, did you receive a copy?
Yes, I did.
Okay, and Mr. Lakey, did you receive a copy?
Yes, I did.
Okay, all right. Ms. Turnbull, I read over your report and I've taken notes. Do you have any highlights or anything that you would like to add today?
No, I think it's all included in the report.
Okay. All right. So basically, in reference to Rosie's the child, correct?
That's correct.
And you've talked about Mr. Lakey's domestic violence treatment, and you've talked about the reunification counseling, where that stands, information about Ms. Brandhorst, and all that information. So I'm just kind of looking over my notes and kind of verbalizing it. So I'm here now. I'm fully here. Okay. So thank you, Ms. Turnbull. I'll hear from you, Ms. Jones, and then I'll hear from you, Mr. Lakey, as to your input or your thoughts about that report on what you want or don't want.
Okay. I'm imploring the court today to follow the GAL recommendation that counseling with Ms. Brandhorst stop immediately. Further, I'm asking that the reunification process stop entirely. I outlined the issues in my declaration to the court, which I filed on April 3rd, 2024. I feel the issues that I cited are well corroborated by the Guardian report. Our son's visits were suspended approximately 2 years ago. And why a vulnerable special needs young lady was forced to continue visiting, I'll never know. And subsequently, at that mark, the 2-year mark when our son's visits were suspended, is when all of the allegations of the molestation started. During that time, Mr. Lakey stepped out of the children's lives. There was zero stress. There were no attempts at interference. There were no bogus calls to various agencies. The children didn't even need to be in ongoing counseling. When Mr. Lakey interpreted my attorney's motion for default as me, quote, forcing him into reunification counseling, end quote, all the drama has started up again. And in the course of the Guardian's involvement, there was yet another CPS unfounded investigation. Even Mr. Lakey's choices for the collateral interviewees proves Mr. Lakey's continued bad faith behavior. Out of all of the friends and family that Mr. Lakey could have chosen, he chose my husband's ex-wife and my stepdaughter. This is a glaring example of the continued attempts at drama, manipulation, and chaos, and this choice certainly doesn't reflect our daughter's best interests, in my opinion. If there's anything the court can do to stop the harassment directed at my family from Mr. Lakey and Ms. Lumpkin, I would ask for any relief the court can offer. We are to the point of exhaustion with all of this. The Guardian report addressed the continued false reporting from Ms. Lumpkin, but fails to note Mr. Lakey's complicit behavior to that end. The continued false reporting even continued with the Guardian. I don't feel that Mr. Lakey is invested in this process. I've attempted multiple times to get him to come to the table with a settlement. Mr. Lakey can plainly see and hear that this process is not helping our daughter, yet it persists. And Mr. Lakey didn't open up his home to the Guardian report, if I'm understanding correctly. This Guardian did not go to his home. That's something that I was told was mandatory. I'm just asking that our daughter's efforts be acknowledged and her wishes to stop this process be considered by the court today. Thank you, Your Honor.
Thank you. Ms. Jones, in some of your pleadings, you talked about the importance and necessity of understanding your daughter's, I think it's called charge syndrome.
Correct.
Can you just give me a little more detail? I recognize that there are different descriptors of potential symptomology, and autism might be one of them, but I just really didn't have a clear idea of how that manifests in her life. Could you share that?
So charge manifests in her life with developmental delays. It does manifest with autistic-like behavior. Charge also is manifesting in her eyes. She has very poor eyesight. She will never be a driver because of her eyesight, and we have some ongoing medical expenses that are coming up related to that as well, that I anticipate some issues splitting those costs with Mr. Lakey. Aside from her developmental delays and the autistic-like behavior, that's pretty much it besides the eyesight. She has had open heart surgery. It did affect her heart. She does have a cleft palate. So there are some issues that make her not typically developing.
Is there a general idea as far as like the developmental delays where they're most pronounced?
Most pronounced would be in like retention. So if she reads something at school, sometimes retaining it isn't always easy for her.
Okay. And as far as social interactions, does charge impact that?
Her social interactions are best with her fellow Special Olympics athletes. That's been a great space for her to form friendships. Sometimes interactions with peers are not typical. So.
Okay. All right. Good. Thank you for that added insight. I wanted to ask Ms. Turnbull, I think in your report you indicated you did a video visit of Mr. Lakey's home.
Yes.
Okay. All right. Thank you.
That was my choice. That was not because Mr. Lakey refused it. And if the court would like, I would be happy to go back and do an in-person of his home. That was partly due to my time and because Rosie was not actually in his, doing visits in his home at this time.
Thank you. I was just an inquiry for because Ms. Jones had raised that. Thank you. Mr. Lakey, I'll hear from you, please.
I don't know how to really put this. One of the reasons in doing my DV counseling and also in talking to Ms. Brandhorst, which was several months before I did my DV, that I made a mistake. I should not have done what I did. I backed off because of what Rosie was going through with visitation. One of the reasons I asked for Diana Berg, Dan Jones's ex-wife, was because Lindsay, seeing before Rosie would come to visit me before the arrest and everything, that they would pray over her for her protection, which can be also a form of abuse because it's building up in the child's mind that I'm a bad person or that Christy Lumpkin is a bad person. And that's why I had that, because you can look at it two ways. You can look at it, yeah, they want to have protection for their child, and the child, is, as far as religion, has, God will protect me. But it can also be a form of abuse and also a form of manipulation into thinking that I'm a bad person. So while they're here, the visit doesn't go because they're afraid to say anything or do anything because they will get in trouble. And that was not the case or anything. And going through with Barbara, I realized that I had made that mistake and should have kept on after my, I can't think of what it's called, where I can't see her at all after my arrest and everything, a restraining order thing. And I should have, tried to get back into that. I didn't, because I didn't like seeing her go through the turmoil she was going through. And going and talking to Barbara, I realized that I had made that mistake and needed to correct that. And shortly after starting reunification counseling, I came in for a visit where I had found out that the school had called Stephanie Jones several days earlier, that the school had found that Rosie was looking online to find means to hurt herself or end her life. That was very disturbing, and I didn't know quite how to deal with that because I've never experienced that before. And I told her I was sorry that had happened. And in the course, we were doing good up until the time that Miss Brandhorst wrote the letter about unsupervised visits. Then it went the whole thing changed. And after the second letter, it changed even more to back to what it was when we first started. Is like, no, we're not going to do unsupervised visits or anything. That has been my goal the whole time. That's why I'm doing the reunification counseling, is to reach that goal of unsupervised visits, having visitations on the weekend like I used to. And that's why I also did the assessment, got the assessment done, and did the 26 weeks of therapy for a group and everything. And in the report, I see that Mr. Case has recommended that I am not, how do you put it, a bad person, I guess, that I'm safe. Ms. Brandhorst has also recommended and said that I am safe. And even Olivia Lovely, when I had my assessment done, said that because of the mandated, hey, you have to do whether or not you're a good person or not, you have to do a minimum of 26 weeks. And I was considered low risk by her as well. So I'm really having a hard time, you know, with wanting to get back to unsupervised visits. That's why I'm here. That's why I'm doing all this and put the money and the time into this. And also, yes, I did Diana Burke, and then I also had 2 other references that were never contacted as well.
Okay. Thank you, Mr. Lakey. Ms. Turnbull, any points you want to highlight at this point?
No, I did contact Mr. Lakey's son also, but didn't hear back from him until after the report was filed. I do think that one of the problems is that I think that you can see that there is Jones and you know, is definitely concerned about the reunification moving forward. Mr. Lakey definitely wants it to move forward. I have not found any professional third-party resources that are concerned about Mr. Lakey, besides Ms. Jones and Rosie. And so they are stuck right now. And so this is a hard position.
Thanks, Ms. Turnbull. Ms. Jones, I'll give you a moment to reply. Yes, go ahead, Ms. Jones.
So actually, Your Honor, Ms. Turnbull did in fact cite a CPS report from 2014 where our son Noah had reported physical abuse in our home by Mr. Lakey. So she does in fact have professional proof that there has been ongoing abuse. That's 10 years. There is a consistent pattern of abuse. And the issue is no one listened to my children until the point that Mr. Lakey got arrested. And then all of a sudden it was like, maybe we better listen to the kids. There are reports to counselors. There are reports to CPS. There are reports everywhere documenting the abuse. Ms. Turnbull herself documented it. So to say that there are no concerns about him going forward, I struggle with that. I struggle with that a lot because there are concerns. There is complicit behavior with the false reporting, even to this guardian. And so I really do struggle.
Thank you, Ms. Jones. Okay, well, obviously the case is challenging at this point. There was a period of time where as you know, self-admitted by Mr. Lakey, that he did pull back, and that the reunification counseling has been ongoing for an extended period of time, months, pretty close to a year, if not over a year. And in its current form, the reunification counseling is pretty much stalled. It's kind of dead in the water, and there's no fuel to the motor at this point. And so Ms. Brandhorst has recommended back in December, I believe, for community visits as a means to kind of jumpstart or get some fuel to the motor. So that's her recommendation. Ms. Jones is adamantly opposed to that. She wants to stop Ms. Brandhorst's involvement, wants to stop the reunification counseling, and echoes strongly states that Rosie's voice needs to be heard. And Rosie's indicated that it's kind of nuanced here, I think, because Rosie indicates that she's done, doesn't want to do the reunification, and Ms. Brandhorst gives some glimpses of, well, maybe that's not completely and wholly accurate. For example, she'll sit down next to her father and she'll after kind of holding back a smile, will actually smile, and there's kind of this shell there that has developed, and that may be part of this charge syndrome that has been mentioned and emphasized, and autistic-like qualities and having continuity and patterns is really important for the children that suffer or have those, not necessarily suffer, but have those conditions and those tendencies within their life. So what I've seen is that Mr. Lakey involved himself in domestic violence training for 26, half a year. And the individual there indicated, they opined that they didn't feel that there was any safety risk to the child. Ms. Jones points out in 2014, I think the son's name is Noah, if I'm not mistaken, that there was a CPS report related to that. I don't have any direct information other than that was raised at that time. There's no CPS. The most recent CPS items have been unfounded. So there's that. There's the issue of past maybe pulling back or abandonment, if you will. I think the reunification counseling that's ongoing for months, if not a year, show that Mr. Lakey has re-engaged and shows that he's interested in moving forward. And I recognize Ms. Jones indicates that, well, that's just because Ms. Brandhurst is pushing him to do that. Be what it is, there is that manifestation of intent to establish or improve the relationship between father and daughter. So other than, it sounds like when Rosie goes to the reunification counseling, there's some anxiety issues that manifest themselves. And other than that, at this point, there don't seem to be any super large physical safety concerns or emotional safety concerns. So at this point, I think Ms. Brandhurst recommends, kind of, since the reunification counseling is pretty much stalled, she feels they've done as much as they can in the current setting, that she recommends up to 3 hours of community unsupervised visitation, with a strong emphasis that Ms. Lumpkin not be present during those visits. And she asks for kind of tune-up visits, reunification visits in between those community unsupervised visits. That's the recommendation from her. So I think that suggestion is well taken. I recognize that there's big concerns on Ms. Jones's end about her daughter, and I recognize also that Mr. Lakey has engaged himself for an extended period of time, manifesting a desire to try to improve that relationship. And whether there's an unwitting impact or an intentional impact that's impeding the reunification counseling, I'm not sure. Is that a possibility? Yes. Is it possibly not there? That's also a possibility. So I think that I'm persuaded by what's been presented to me here today, and also in the pleadings, that that one time, I think the recommendation, correct me, Ms. Turnbull, that the recommendation was 1 time a month, or was it 2 times a month? I think it was just 1 time a month. Was it not on a Saturday?
For the visits, or for
the visit? For the visit.
With Ms. Brandhurst, or for the community visit?
Community visit.
I think I'm sorry, I don't recall. I thought it was more often than once a month.
Yeah, maybe Mr. Lakey, can you do you have any input on that?
I think it was bi-monthly in the community, up to 3 hours, followed by a reunification visit to process any occurrence.
How many times?
I might add.
So two times a month.
Yeah.
All right. Thanks.
The problem that we're having a lot of at reunification counseling is rehashing everything over again. And I have, said, I'm sorry, I've done all of that. And the past can affect people, and I get that. I have things in my past, parents, dying and so forth, that still affect me. I get that. But in order to move forward, we've got to put some things in the past and move forward. And that's what's been hard these last 4 months. In fact, since December, I haven't talked to her on the phone. I've called, and recently I started leaving messages.
So Mr. Lakey, do you mind if I interrupt? I know you're explaining things that are important to you. I was just I was kind of in the midst of sharing my ruling, and so let me just make that clear. And if there's any questions related to that, we can clarify. So, so I'll allow two visits per month on Saturdays, alternating. Just so that there's no confusion, it'll be the first and the third Saturday of each month, and it'll be up to 3 hours. It'll be in the community. It'll be unsupervised, and Ms. Lumpkin is prohibited from being at or near the visits. And then on those off weeks, on the second and fourth weeks, that'll be the counseling sessions with Ms. Brandhorst. I think I'll ask Ms. Turnbull. I'm thinking of setting a review hearing 2-3 months possibly in the future, just to get a status update from how those in between counseling sessions are going, and also how the community visits are going. Do you have a recommendation on timing?
Yeah, I think 3 months would be good.
Okay. Ms. Jones, do you have any recommendations as to timing of a review hearing?
3 months is fine.
Okay. Mr. Lake, are you okay with that?
Yes.
We'll come back on July 10th for a review hearing to make sure everything is going well.
And would you like me to stay involved at this point?
I don't necessarily think is necessary at this point to stay involved. If it comes later at a time where it feels like you should be re-involved, then I think you could be reappointed. But at this point, I think you've provided the input that the court needs.
Okay. All right.
Okay. So let me ask if there's any questions or clarifications from the parties on the court's ruling, Ms. Jones.
So you are wanting this to stay with Ms. Brandhorst despite the guardian's recommendation?
Yeah. Yep. I think there's a lot of history there that needs to be addressed, and I recognize a lot of history may be an impediment also. But I think in making that determination, I was thinking about a child who has autistic-like symptoms, and having her go through community visits and then having a new counselor. I thought it might be a little much, and so that's why I made that decision to foster continuity, even though it may be problematic. Okay. If there's no other clarifying questions, I'll prepare a bench order that reflects that ruling, and then I'll file it no later than Friday afternoon. And if you need a copy, you can get a copy.
Would you be willing to include in that my discharge then in the bench order?
Yes. I'm just including that last little item there, GAL discharge. So I'll include that.
Thank you, Your Honor.
All right. So that'll conclude today's hearing. Thank you. If Tasana Burkett is on the line?
Yes, Your Honor, I'm here.
Great. Welcome to you. Did I pronounce your last name correctly?
Yes.
Okay, great. And is Shane Llewellyn on the line?
Yes, Your Honor.
Okay, welcome to you, Mr. Llewellyn. We're here on a motion to modify a parenting plan. There was adequate cause was previously found back in November, and at that time there was kind of some tweaks to the parenting plan, and the ruling on the parenting plan was reserved. And so there was an interim parenting plan back in February that was kind of put into place, and then we're here today to get an update on how those overnight visits are going. That's kind of my understanding of why we're here today, and I'll ask Ms. Burkett if you have a different understanding of why we're here today.
No, I think that's pretty accurate. I know Shane was asking for some more time. He was going to ask for 2 overnights instead of just the 1. He also wanted Wednesdays, and I think the summer schedules, he wanted like every other week for that. I did have some issues with that. I was willing to come to a middle ground with Mr. Llewellyn about what he wanted and about what I wanted. And then I did bring it up to Abel about having the 2 nights, kind of gauging how he felt. And I mostly thought he was going to be pretty excited about it because the visits have been going pretty well. Abel did express to me that he likes the 1 night. In my opinion, he is still a little attached to me. I have been his only parent for most of his life, and I think it has been a lot for him just having the 1 night. But I think it's very good for him. I'm fully on board with that, and I was going to be on board with the 2 nights as well, just until until Abel had told me that he likes things how they are and he wanted just the one night. So I was proposing that maybe during the summertime, maybe we could do 2 nights during Abel's summer, every other weekend. I just think that the week-long visits in the summertime would be a lot for him right now. But I would be willing to speak with Mr. Llewellyn about maybe in the future when he's a bit older, maybe looking into that kind of stuff. But for now, the one week or the one night every other weekend is going really well, in my opinion.
Okay. All right. Thank you. Yeah. Appreciate that. I felt to recognize that Mr. Lawrence, the guardian ad litem, is on the call also, and we'll hear from him in just a moment. Mr. Llewellyn, do you have any input?
So my request for the Friday night overnight stay, it was just going to be like I'd pick him up when I got off work. We'd spend the night together and go to bed a couple hours later, a few hours later, whenever we decided to fall asleep. But it wasn't going to be like a full Friday leading into the night. I understand it would be another day, and I hear Abel and his saying that he likes the one night, but for his understanding, he'll be 7 here in about a month. For his understanding, I think he's seeing it as another whole like block of time, but really it's just a matter of a few hours that gives us more time during our Saturday for the rest of our weekend visit. If you're following what I'm saying there, it's not a full chunk of time. It's just the nighttime, a couple hours we'd get to see each other. So he'd still be with his mom all of Friday, aside from school and whatnot. But I do hear what Abel's saying, and I don't want to do anything he doesn't want to do, but his understanding might be a little different than ours.
Okay, so let me just clarify. So right now you've been doing this alternating weekends of Saturday at 10 a.m. till Sunday at 6 p.m.?
Yes, Your Honor.
Okay, and then your request is to start the visit on Friday after work and extend through Sunday at 6 p.m.?
Yes, Your Honor. And it would work well because my mother is a first grade teacher, and she could take Abel home, and Abel would be able to spend time with his Nana. And then when I got off work, I could just go meet Abel and my mom at my mom's house, pick Abel up, or even just stay the night there with him whenever Abel wanted to do whatever he felt more comfortable with. And then we could start our visit then. So it would just be a time for Nana to see him and a little bit sooner for a start for our visit and give us more time together.
Ms. Burkett indicated that she made comment about the summer visitation, the week on, week off. She felt that might be a little too much at this point. What's your viewpoint?
Honestly, I don't really disagree with her, but since this is the final parenting plan and this is going to be until he's 18, I was just trying to do what seemed appropriate. And then I was hoping that during our meeting, we could kind of come together on some sort of an agreement that kept the terms of the week on, week off, but her and I be cordial in visitation time and like talking. If Abel wanted to go back to her, if he felt that the time was too long, then we could do so, kind of thing, and then maybe come back after a day or so. But just to actually get the week on for week off set, since it's going to be till he's 18. I do agree, though, that is a long time for him, and even before I made that statement, I thought that. But since it's going to be till he's 18, I figured getting something set would be the right thing to do, and then hoping to come up with a plan to work for everyone, if that makes sense.
Is there a time frame in which you feel Abel would be better suited to do well with that type of week on, week off, like in 2 years and 3 years and 1 year, 5 years?
Probably 2 years.
Okay.
I was also thinking about the ages like 9 or 10 would be a little more appropriate for the week on, week off.
Okay.
That would be the 2 year mark because he'll be 7 May 7th. So.
Yeah.
Okay. All right.
If there was some way that we could, like, just to keep us, because we're hoping to be out of the court system. We've been in here for years now. If we could somehow set the week for week in the summer and then come to an agreement on something, just so it is set, but also that appeases both parties and Abel included. So I guess 3 parties. Do you catch what I'm trying to say here? I don't really know because we haven't figured it out yet, but.
Yeah, I understand what you're saying. Yeah, I hear what you're saying. Okay. Thank you, Mr. Llewellyn. Mr. Lawrence, do you have input?
Yes, Your Honor. Shane is correct. This has been going on for a number of years. And he's finally gotten the appropriate medication. He's cooperative with the treatment, and so his behavior has been extremely stable over the last couple of years. And he was awarded the ability to have day visits on Saturday and Sunday. And then that was increased to overnight. And it was my understanding that that would be the final parenting plan. In reading the two parenting plans submitted by the parties, it appears that Shane is now pushing for a Friday and also week on, week off during the summertime. And although Tasana has indicated that there are no issues, she is asking the court to impose sole decision-making authority. And it seems to me, in listening to the discussions today, that the parties could probably sit down and iron this out. My usual recommendation in a situation like this would be to have a layered approach on the parenting plan where the child have limited contact until they get older and then increase the contact based on their age and maturity level and ability to separate from the parents emotionally. So I think we're all moving in the right direction. The question is can the two parties just sit down, iron this out, or do we need an MSC, or what do we need to resolve it finally?
Okay.
Your Honor, may I say something quickly?
Sure.
So I also wanted to just let Shane know as well, if the week on, week off visits aren't in place, say until he's 9 or 10, if Shane wants to plan something during the summertime, a trip that lasts longer than his one night, I have no problem talking through that and having him able to go to the beach for a few nights in a row or however that works out. But yeah, that's it. Sorry.
No, that's fine. Thank you for the input. Okay. So in looking at the different proposals that the parents have mentioned, it sounds like you're getting along fairly well, and it sounds like you're focused both on your son's well-being and his needs, and that's very gratifying and very encouraging. So good job for both of you for doing that. So here, the indication is that Mr. Llewellyn has made improvements. He's doing better. His stability is present, and there's still some concerns and reservations from Abel's standpoint as far as comfort level and the like. So taking those things into account, a parenting plan is kind of a base document. So as a general rule, if the parties feel like they need to deviate from a parenting plan, they're free to do so if they both agree. And I think that allows some flexibility for children, and because we recognize children are not static, nor are parents, and life happens, if you will. But if there's ever a disagreement, then that parenting plan becomes the rule that everybody needs to follow. So if somebody wants to deviate and the other party doesn't want to deviate, then the parenting plan controls the situation. But if both parties feel that this would be a good deviation for the benefit of the child, then you're free to take care of your child in the way you see fit. So at this point, the request is to expand it to a 2-night visit, which would be from Friday after work until Sunday, which would be an expansion from the Saturday morning until the Sunday. And then also there's, I think Mr. Llewellyn has pulled back from the summer visits, asking for a week on, week off. And I think it sounds like, from what I heard from both parties, is that maybe starting that in future years. So probably the summer of 2026 is a potential, and so we could have kind of a graduated plan that approaches that particular year in that summer. So I think that there's the parenting plan which still does require Mr. Llewellyn to submit monthly medication management records and appointments. And then also there's the testing for Ms. Burkett that's still in place as far as monthly alcohol testing, if I'm not mistaken, looking at the temporary parenting plan from back in, I think it's November roughly of 2023. So I didn't hear any requests that any of those things change. So I don't see any reason to omit or take those out from any continued parenting plan. What I do think is permissible at this point is to allow the Friday overnights to the Sunday on those alternating weekends to start. we're going to hold off on the summer alternating weeks and just say that the summer visitation would occur at kind of the alternating weekends. And if there's special events, obviously you all can agree if there's something that would be good for Abel, you're welcome to do that. Then otherwise the week on the week off would start in the summer of 2026. And as far as decision making, Mr. Llewellyn has made a request that that Ms. Burkett have sole decision making as to school and education, and he's asking for joint decision making for non-emergent healthcare and also religion, whereas Ms. Burkett indicates that she's desirous to have sole decision making as to school and healthcare. One thing I didn't hear from Ms. Burkett is your viewpoint on religion. Generally, what I've seen is that orders will say each parent is able to involve their child in their particular religious preference during the time that they have the child with them. So any objection from either party related to that?
No, Your Honor.
No, Your Honor.
Okay. Okay. And so as far as decision making, as far as education, that'll be sole decision making to Ms. Burkett. And then as far as the non-emergent healthcare, can the parties just briefly address that for me and just give me your viewpoint on whether that should be sole decision making to Ms. Burkett or joint? Ms. Burkett, do you want to go first?
I may have put sole decision making. I think I got confused exactly what it was. For non-emergency, I have no problem having it be joint.
Okay.
You know, he needs medical care and he's with Shane. I absolutely want him to get it. So
sure. Okay. So we'll make that joint.
My apologies on that.
No worries. Thanks for the clarification. So for the non-emergent healthcare, that'll be a joint decision making between the parties. So there was proposals related to holidays that the parties, at least there's Mr. Llewellyn's was a little more complete and Ms. Burkett was a little more pointed in the ones that she was asking for. Ms. Burkett, do you have any concerns as far as the kind of the alternating nature of the different holidays?
There was one in particular. It was the Christmas one. I believe it said that Shane wanted every Christmas to be Christmas Eve with me until about 8 p.m. And then it was going to be Christmas every Christmas morning, waking up with him and Shane together. And I definitely would rather that be alternating, if anything. Abel has, I mean, last year we did a situation since Christmas Eve landed on a day that Shane had him already. Abel was a little disappointed that he didn't get to spend Christmas with his cousins and with my family. He has a pretty strong tradition with my family since it has been just us for, approximately 6 years. And I think it was a lot for him to kind of know that he was going to be missing out on that with Mr. Llewellyn. So I was asking for every Christmas, unless it happens to land on that weekend, just because that's what Abel had expressed to me that he, that's what he's used to. But if anything, if it does go the other way, I would ask that we alternate and it wouldn't be every single Christmas morning with Shane. So.
Okay. Thank you, Mr. Llewellyn.
The only reason that I had stated that is from I was trying to recall based on memory. I thought that Miss Burkett always did her Christmas on Christmas Eve, so I was trying to accommodate for that since they celebrate their Christmas then, unless I am forgotten on that or mistaken. But I thought since they would celebrate their Christmas then, and it's already all said and done, that they could spend the rest of their day, and then at nighttime, I could have Abel so he could wake up for Christmas morning. But I didn't take into account the other family that Abel would want to see, not just the immediate family of Tessana's. So in that case, I think that every other year, alternating would be ideal.
Thank you. As far as the there's a request for a midweek visit that we didn't touch on that, so I want to hear from Ms. Burkett.
Yes, and that was one of the main things that I would ask that the court not impose, simply just because Mr. Llewellyn doesn't really get off work until about 7 o'clock in the evenings anyways. And we have tried to do this in the past. It was with a supervisor, but it was every other Wednesday, I believe. And it was very hard for me during the school year to get able to calm down after these visits. We try to go to bed at about 7:30 every night. So he would come home at 7, be really wound up. It was hard to get him back into his routine, and we are pretty busy during the week together. So I really ask that the Wednesday visits not be imposed if possible, just due to Abel needing that time at night. So.
Okay, thank you, Mr. Llewellyn.
Yeah.
I don't disagree with the whole time at night thing. He does tend to want to stay up with me when he's here and not go to bed until like, you should be in bed, buddy, kind of thing. My job did tell me that they could let me get off work early, kind of thing, on those Wednesdays. And honestly, the main reason that I was trying to set the Wednesday is, again, because this is going to be till he's 18 and this is our final parenting plan. I wasn't like, yeah, I'd love to see him on Wednesday, but it wasn't a dire need. It was more so for future, since this is going to be the final plan till he's 18, if that makes sense again.
Does, thank you. Mr. Lawrence, do you have any input on that?
The only input would be that Mr. Llewellyn be available during the time if the court imposes it.
Okay, thank you. Okay, yeah, as far as the Wednesday afternoon, if Mr. Llewellyn is getting off at 6, 7 o'clock at night, and the time frame for the visit is 3 to 7, an hour visit is really not ideal. So I think I'm okay with a visit time from 4 to 7 p.m. on Wednesday, and with the caveat as expressed by Mr. Lawrence that Mr. Llewellyn must be available during that time frame for the visits to occur. If he's not available during that time slot, the 4 to 7, then the visit wouldn't happen. But if he's available during that full period, then the visit would happen. And just want to confirm that as far as the exchanges, is still good with the Woodland Park and Ride?
Yes.
Okay.
Yes, Your Honor.
Okay.
And Your Honor, would it be possible to do that every other Wednesday, or is it every Wednesday?
The proposal was for it to be every Wednesday in kind of counterbalance to the alternating weekends.
Okay.
Your Honor.
Go ahead.
Same thing, being with my mom being a first grade teacher, Abel could go home with her after school kind of thing. I still need to, since this is actually approved, if this is the case, I do need to talk to my boss. He did tell me he's willing to work with my schedule and he has no problem with that, but he didn't know what we were going to get. So he said we'd have to talk more once that was figured out. He said, yeah, I'll work with you, but until I actually know, I don't know what I'm agreeing to, kind of thing.
Sure. Okay, so I'll allow the Wednesday visits 4 to 7, and Mr. Llewellyn has to be present and available during that entire time. And if he's able to work that with his schedule, great. If not, then it just won't happen. All right, so I think that covers all the issues. I'll ask any party if you have any questions or clarifications.
There was one last thing. It had to do with the taxes. I know Mr. Llewellyn wanted us to do or claim Abel on taxes every other year. And I was requesting that I get to claim him every year since I'm the custodial parent and I have him the majority of the time. But I just wanted to clarify what the final ruling was on that.
Is Mr. Llewellyn paying child support?
Yes.
Yes, Your Honor.
Okay. All right, Mr. Llewellyn, do you have an input on the tax exemption?
No,
I hear what she's saying about being the custodial parent, but I don't know. My request was my request, and whatever you decide is decided.
Just typing something. Okay. So the general idea here is, with the tax exemption, both parties are expending funds. They're expending them in different ways. A primary custodial parent is kind of the continual regular expenses. There's heating, there's schooling, there's water, food, clothing, and the like. And then the parent who's paying the child support, those funds are being expended also, but just in a different way, kind of more lump sum type expenditures. So my general rule is that if the non-custodial parent is current in their child support as measured by the January 15th of the year following the tax exemption year, then I'm usually okay with both parties splitting that child exemption or the tax exemption. So I'm fine with that, and I'll grant that. Ms. Burkett will have even years. So for tax years 2024, 26, 28, she can claim Abel, and Mr. Llewellyn can claim, if he's current by the January 15th following the tax year, he's able to claim it in odd years. So that'd be 2025, 20. Or 2023, 25, 27, and so forth.
Okay.
All right. Any other points of clarification or items to be addressed?
There was one I was wondering.
Okay.
I understand that Abel isn't going to always want to talk to me like every single day, but if we could get it to where if Tess and I made contact with each other beforehand to see if Abel is open to a phone call, that we could approve every night or whenever Abel's wanting to phone calls. Just because I go like 2 weeks without seeing him kind of thing. And I do right now have the Tuesdays and Thursdays, and it isn't fully set based on our last court date. You said that we can kind of talk with each other about that, and if we can agree on something, then we can do so. But I was just wondering if we could get whenever Abel wants to talk to me kind of thing, possibly every day if he's even up for it. Phone calls.
Thank you. Ms. Burkett?
I also wanted to talk about that. Even just the Tuesdays and Thursdays lately, I'm not trying to hurt anyone's feelings. He is only 6, and I think he's not a big talking on the phone kind of kid, but it's been very hard to get him to want to talk on the phone to his dad. Usually I have to prompt him, I have to ask him a couple times, and then it has to be a thing where it's like, okay, now you have to sit down and talk to your dad. And I hate having it to be that way where it's like, this is something you have to do. The rule is you have to talk to your dad right now. I was even going to ask that maybe we could reduce it to 1 time per week, but I'm totally fine with it being whenever Abel wants to. I'll never keep the phone from him if he wants to talk to his dad. But I think making it set in stone that he has to talk to him every day or even, every Tuesday and Thursday has been kind of rough over here. So.
Thanks. Mr. Lawrence, do you have any input?
Again, if we're looking at long term, that could be in a couple of years that we could have a more definitive time. And I agree. In all of the cases I've been involved in, the younger the child, the more difficult it is to get them to talk on the phone. And the last thing you want to do is to make it a chore for the child. And so I appreciate Tasana's willingness to allow him to talk whenever he wants to. I guess my suggestion would be to have at least 1 phone call per week, but have the phone available at other times and have liberal but reasonable amounts of telephone conversations between him and Shane. And then as he gets older, then that can be increased and make it a little more formal.
Thank you. And Mr. Llewellyn, any input on that?
I think it's ultimately Abel's decision, and I think we all kind of agree on that. If Abel wants to talk to me 5, 7 days, whatever a week, that's great. If he wants to talk to me 1 day a week, that's his choice, and I don't want to overstep his bounds kind of thing. So.
Okay, thanks. Yeah, I appreciate the difficulty of talking on the phone for smaller children is pretty tough, and you don't want it to be a burden, and you don't want the child to like kind of begrudgingly like, okay, I got to talk to dad or talk to mom. Try to want to avoid that. So I think what we'll do is that the child can initiate a phone call to dad at any time he would like, and then from now until next April 2025, the phone calls would be reasonable times and reasonable durations. So I'll leave it up to the parties to kind of figure that out until then. I think starting April next year of 2025, it'll be Tuesday once a week. And then the following year, April 2026, it'll be 2 times Tuesday and Thursday at 7. And again, it's just for reasonable times and the like. And so hopefully that provides kind of that flexibility. Is the idea is like if you're forced to do something, you're probably not going to do it. But if you like it and it's, you're able to manage it, then it's going to be in the long term better, I think. Yeah. So I appreciate the input from the parties. Do you have any other issues that we may have missed?
No, I think we're good.
Okay, Mr. Llewellyn.
I think that's everything, Your Honor. There was kind of a lot covered. I wrote some stuff down, but is there a way to pick up like the order that's been written from the courthouse so I know specifically?
Yes, I'll draft it and I'll have it done by Friday afternoon, and it'll be filed at that time. And then generally 2 to 3 days thereafter, business days, you can pick up a copy.
Thank you, Your Honor.
Okay. All right. Mr. Lawrence, any final items?
Well, Your Honor, I'm really proud of how Tasana and Shane have progressed over the years that I've been involved in this case. It seems like kind of a natural ending point for my involvement. And so I would ask the court to relieve me of the appointment.
Okay. Any concerns if we relieve Mr. Lawrence from his appointment?
No.
No, Your Honor. Thank you, Mr. Lawrence.
You're welcome.
All right, Mr. Lawrence, I'll go ahead and include that within an order discharging you.
Thank you.
All right, thank you all. Appreciate your efforts, and that'll conclude the hearing, and I'll get that filed by Friday.
Thank you, Your Honor.
All right,
Thank
parties
you.
are present. We'll start off with Joshua Harris. Are you here?
I am.
Okay, welcome to you, Mr. Harris, and Elise Harris, and hopefully I pronounced the first time correct. Elise Harris, or Allis? Mr. Harris, is it Elise?
Her name is Alice.
Alice, thank you. Alice Harris, if you're on the line, please state your name. Alice Harris. Let's see, I'm just going to double check the participant listing. Okay, so I don't see her on the line today. It's noted today that it was on today for her motion for adequate cause and her motion to adjust child support. And that she had made mention of maybe merging this case with a guardianship case. So what I see, Mr. Harris, is that Ms. Harris did not file a proof of service that she'd been served with a summons. So case really can't go forward today. And I recognize you've been on the line an hour and 42 minutes, so my apologies for that.
That's fine.
So I think at this point, without the petitioning party here, Ms. Harris, without her being present and without service, I think that we strike the hearing. If this is something that she wants to pursue, she'd have to renote it and make sure her service was properly effectuated.
Okay.
So I think that's what I'm doing, is that I'm striking the hearing, and then we're not taking any action on it. If she wants to take action on it, she can make sure those requisites are fulfilled, and then we can move forward. So, Mr. Harris, any questions?
No, that sounds good to me.
Okay, all right. So that'll conclude that matter for today. We're just simply striking it and not hearing the matter.
Okay, I appreciate your time.
All right, thank you.
Yes, Your Honor.
Okay, welcome, Mr. Dooley. And Kiana Morris, are you on the line?
Yes.
Okay, welcome to you. And I see that Ms. Corey is here. Welcome to Ms. Corey. We're on today for a motion brought by Ms. Morris related to a motion for temporary child support and a motion to waive guardian ad litem fees. As far as the child support, I was looking in the file, and I'm just going to pose my question to Ms. Morris. I didn't see a declaration or affidavit of service on Mr. Dooley related to the child support. Did you serve him with the child support paperwork?
So we originally served the child support paperwork back in November, and we had a court date November 30th, and he didn't sign off on anything but me leaving the house, and I just wanted to go back to that same child support that we filed.
Okay, so if I understand you correctly, that there's a current child support order that's in place, and you're wanting to just leave that as is?
No, there's no child support in place. We filed a temporary one, and nothing was signed off on it.
All right, so there's no child support order currently?
Yes.
Your Honor, if I may.
So I'm really good at letting people finish what they need to say. So, Mr. Dooley, if you could hold on 1 second, I just want to make sure I'm understanding her position. So I guess my question, Ms. Dooley, it relates to service of any proposed child support orders and information related to that. So you're saying that happened back in November of last year?
Yes.
Okay, so that's where I see a proof of service related to a proposed parenting plan, children in between certification, motion for temporary family law order. Is that the one you're talking about?
I believe so. I don't know. I know in I think the parenting plan had the child support attached to it.
Okay, I'm just looking back in the November range of declarations or affidavits.
Okay.
So the case was initially filed back in early October with the petition. Then there was a motion for temporary order that was filed by Ms. Morris. And let me just take a quick look at that there. Hold on.
Okay.
Okay, so in that motion back on November 7th, there was a motion for child support and also spousal maintenance. And then there was a document showing service of that motion. And then there was a later in time, November 14th document filed by Mr. Dooley, where he indicates that he does not want to have support nor maintenance obligation. Like he served Ms. Morris with that. And I'm looking for, generally there'll be some financial declarations or financial information that is supplied by the party, so I have an idea of what your incomes are. Ms. Morris, did you submit anything related to that?
Yes, there was one of the papers that I just submitted with this docket that had mine, but I do not know Jacob's income or anything.
Okay. All right. Okay. Well, thank you for exploring that with me. I appreciate that. Mr. Dooley, I want to just focus, if we can, just for a moment on the service issue as far as child support, because that's one of the motions why we're here today. Did you receive service back in November of Ms. Morris's motion?
The service that I received back in November, yes.
Okay.
The court hearing that we had about that one, the judge did not grant temporary child support due to the fact that he wanted to place a guardian ad litem to see how the custody was going to go. So he appointed a guardian ad litem to our case to actually go over it with us and see how we are going to go through with the custody hearing before the child support.
Yeah, I'm looking at minutes from November 30th, and that I think that's supported by the minutes from that hearing, that the temporary child support was reserved until we figured out what the parenting plan was going to be.
Yes.
Okay.
And this new one that got brought up for this docket, I went home for a few days because I am currently in Arizona attending school, and I got home on a Thursday morning, actually. She waited until Sunday before the night that I was leaving, when she came and picked up the kids, to tell me that the papers were in her passenger seat, and they were pictures off her phone that were printed off the printer. They were not copies from the court. There was no actual anything stating that I have been served. It was just copies.
Okay. All right. Thank you. So with regard to the motion for temporary child support, right now, there was that November 30th hearing, which the judge says, hey, we're not going to talk about child support until we've figured out the parenting plan. Looking at the case file, I don't think the parenting plan has, quote unquote, been figured out, or there's a temporary parenting plan in place. Is that accurate?
Correct.
Yes, he lives out of state, so the kids are with me.
Okay. All right. So that's still pending. And so I think that oral ruling by the judge back on November 30th, that we need to get the parenting plan in place first and then decide child support. I think that's important that we abide by that. Also, if we're to move forward on a child support, which we're not going to do today, we need to have information related to the incomes of both parties. So we have an idea. I think I saw some information from Ms. Morris related to her net income and her costs, mortgage and childcare and things like that. But I don't know. There was some indication back in October that Mr. Dooley's net income was in the $6,000 range, but then he had moved to Arizona. So I don't know what his
if anything, it's gotten
condition.
higher.
Yeah. So at this point, I think we're not in a position for me to make a decision on child support, because I really don't have any information. But so I think what needs to happen, because this case is somewhat disjointed, in that usually there'll be a motion for child support, but here with this case, I think the judge indicated earlier that there needs to be some type of parenting plan in place, so we know the contours. I think we generally know that Ms. Morris is the primary custodial parent at this point, because Mr. Dooley's living out of town. But I think we need to abide by that. So I think probably two things need to happen. We need to have a ruling on a temporary parenting plan, and we could make that decision. And it could be on the same day that we could make a decision on child support also. So but I need both parties to submit updated information related to finances. I need both parties to update information related to the parenting plan, which you think is going to be the best for the child or the children. So that's a long way for me to say, as far as a motion for child support, I don't think I'm in a position to rule on that today, just because I don't know the finances of both parties. But I think it still needs to be addressed. It sounds like that's an important issue, the support of children. So we could look at setting that at a future date. Both parties could submit updated information related to your finances, and you could also submit proposed parenting plans of what you think would be a good parenting plan that would meet the best interests of the child or the children. So that's what I'm thinking. And I'm looking at a date in the future to give parties enough time, because it's quite a bit to do. But I'm looking at either May 1st or May 8th. And if either party has a preference, please let me know.
Not currently, Your Honor. We are working with Twyla to try to get a parenting plan. Every time that me and Ms. Morris have tried to come up with one, for one reason or another, the other party denies it. And so that's what got the guardian ad litem put in place to begin with.
Okay. All right. So no preference for you as far as date. Ms. Morris, do you have a preference as to date, May 1st or May 8th?
May 1st. And will I be able to apply for back child support? Because he hasn't supported his kids for going on a year now.
Yeah, you can make that request and he can respond to it. Yes.
Okay.
So when we come, go ahead. Sorry.
With that information, she calls me and asks for anything. And most of the time I will either send her something, or the last week I've bought groceries for the house, and 2 days later she called me saying that they were out of milk again. I had that set up for pickup from Walmart. So I am still buying stuff from Arizona for the house. I have receipts for that in my email.
Yeah, so we can talk about that when we come back on May 1st, and you can provide all that information in declaration form. So when we come back on May 1st, what I want from both parties is I want you each to provide or prepare a proposed temporary parenting plan. So, and then with declarations. So, and a declaration from you or others as to why you think that's going to be in the best interest of the child. So you'll need to file that and then submit copies to the guardian ad litem, and also submit copies to the other party. And then I also asking both of you to prepare proposed child support worksheets and also financial declarations. Basically, you can go to the courts.wa.gov website and go to the forms section, and you can find forms there where you can just use a declaration and also child support worksheets. So I can have an idea of what your incomes are. You'll need to file that with the court, send a copy to Ms. Corey, and also send a copy to the other party. So on May 1st, those are the things that I'll be looking at. Does either party have any questions?
No, Your Honor.
Okay, Ms. Morris.
No.
Okay, so that's the plan. That's the plan moving forward. So we'll address the temporary parenting plan, and then we'll address temporary child support on May 1st. And Ms. Corey, do you have a comment?
I do. I was wondering if the state is involved in this case. I believe that there is some that they maybe should be. I'm not sure if they are.
Yeah, at this point, I don't know if they are involved, but is the child receiving any state supported services, either health insurance or TANF or anything of that nature?
Food stamps.
Ms. Morris, do you know?
Yes, we are on food stamps. And then what was the other one that you said? They are on Washington
health insurance.
State Health. Yes, all three.
Okay. Yeah. So
they're also on tribal healthcare, and then they've got healthcare through my work as well.
Okay. All right. So it's likely that the state may be involved, at least for a duration or for a period of time. So I think also, besides when you file your documents related to the child support, you'll need to send a copy over to the child support enforcement people. Okay. So any worksheets, any proposed orders, and any declarations, financial declarations that you file, not only have to be sent to the other party, to Ms. Corey, but also to this division of child support. Okay.
Yes, Your Honor. Okay.
Just a heads up there. Thank you, Ms. Corey, for raising that. Any other items or any questions about what needs to be prepared and what will be addressed on May 1st?
No, Your Honor.
Ms. Morris?
No.
Okay, Ms. Corey. Okay, all right. We'll see everybody on May 1st. Thanks for getting doing the work and getting that information to me so we can make a ruling on things on May 1st. All right, thank you.
Thank you.
I'll ask if Barbara Sawyer is on the line.
I am, Your Honor.
Okay, welcome to you, Ms. Sawyer. And then is Cole Norgren on the line?
Yes, Your Honor.
Okay, welcome, Mr. Norgren. This is a motion brought by Ms. Sawyer, a motion to transfer the case to mediation according to Local Rule 93. Double checking with Mr. Norgren, did you get a copy of Ms. Sawyer's motion?
Yes, sir.
Okay. Maybe I'll just first start with Ms. Sawyer. You're asking for the motion to be transferred to mediation, and then Mr. Norgren, are you opposed to that, or are you in agreement? What's your viewpoint?
I am in agreement. Your Honor.
Okay. All right. Well, that makes the case short and sweet. I should have called you at the top of the hearing so you didn't have to spend 2 hours here. Nonetheless, thanks for your patience. Ms. Sawyer, let me double check. Sometimes people will submit proposed orders, and I have a grouping of them here. So let me just double check to see if you had supplied that. And if so, I can sign off on it. If not, then we'll talk about next steps.
Okay.
Okay, so let's see, Ms. Sawyer. So I do have a proposed order that was supplied by Ms. Sawyer. Thank you. And then it's recommended here, this proposed order transfers the case to mandatory mediation. And then it also splits the cost of the mediation service 50-50 between the parties to address the issue of parenting plan. Any concerns with that split of cost?
No, Your Honor.
Okay. And I've got addresses of Ms. Sawyer.
Yes.
Yes, Your Honor.
Okay. And then Ms. Sawyer, your phone number ends in 2214?
Yes, Your Honor.
Perfect. And Mr. Norgren, yours ends in 0415?
Yes, Your Honor.
Okay, perfect. So with this, I'll sign the order, and then the case would be then transferred to the mediation services. So you'll need to get in contact with them. No problem doing that today, because the court order may take a couple days for you to get a copy if you need that. But I don't think there's anything preventing you from calling that mediation service and setting up an appointment or getting things going. They probably haven't. I think they have an intake process where they gather information and then they look at setting a date that's convenient for both, or dates that are convenient for both of you. So any questions on going forward, Mr. Norgren?
No. Okay. Not that I can think of. The only question I had is due to a restraining order that I was served. How did that affect going to mediation?
That's a good question. Depending on the prohibitions, there may be some physical distance prohibitions that are included within any type of restraining order. The mediation service may have, and I'm pretty sure they do, they have Zoom capabilities. So that, one person may be in person, the other person may be via Zoom, and that may be able to be a way to work around it. But you can check one with the mediation services, because I don't think this is a unique situation of what they've done in the past and how they've worked that out. And then also, consult with an attorney regarding any potential for getting in trouble for not following the order. So, yeah, okay. So hopefully, did that answer your question? Okay.
Yeah.
Okay. Ms. Sawyer, do you have any questions about the mediation and the order?
So for mediation, is there a phone number that I can reach them at?
Yeah, that's a great question. Yeah. Okay. So the clerk gave a good suggestion. They maintain a list of phone numbers such as the mediation service. So if you want to jot this number down, you can call the clerk's office and they'll give you the phone number. Sorry, it's not direct, but they'll give you the phone number of the mediation service. It's 360-577-3016. So again, 360-577-3016. And that's the clerk's office. So you'd call them to say, hey, can you give me the phone number to the Community Mediation Center?
Okay. And then regarding the restraining order, there is a CPS case that is open on Mr. Norgren right now. They did tell me that it would be in our daughter's best interest that she stay with me until the investigation has been finished.
Okay.
So that's all.
Okay, Mr. Norgren, any final comments or questions?
Not that I can really think of as far as that goes. Is that required? No visitation then until that's completed, or what? I guess I don't really know what all that entails.
Yeah, so that particular issue isn't docketed before me today. So generally, there. I think in your case, is there a parenting plan in place?
No.
Okay. So without a parenting plan in place, it looks like the petition was just filed in January of this year. So without there's a proposed parenting plan I see that's been filed, but again, there's no court order related to visitation. So the parties will kind of need to figure that out in light of any restraint orders and the like. So I won't make any ruling on that today. That'll be for a future day. Okay, with that, I've granted and I've signed off on the motion. The parties have the means to get the phone number to the mediation center, and then you'll contact them and then get registered and get things going. And then once you've completed that, they'll send us a report, and then you'll come back to court and go to the next step. Hopefully you can figure things out in mediation, and you don't have to come back and see us. So we'll see how things go.
Okay.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Take care. All right, so that concludes the matters that were docketed on my docket. I'll just give voice to anybody who is here today that was expecting their case to be called, but maybe has not been called.
I do.
Okay, tell me your name.
Miss Sarah Farmer.
Okay, and you are expecting to have a case heard today, correct?
Yeah.
Okay, so let's do a quick check. Your first name is unique enough, it should be pretty easy to find with a search, so bear with us just a moment.
You're okay.
Oh, yeah. Okay, so, and is the other party Ryan Hicks?
Yes.
Okay, so this is the first thing that jumps out at me when I look at the case. It's still loading. It has the third number is a 2, and why that's important is 2 means it's a civil matter. It could be a civil case, could be a protection order, something of that matter, versus a third number being a 3. If the third number is a 3, that means it's a family law type case. So this one is shows that you're the petitioner and Mr. Hicks is the respondent, and you filed back in the one case I brought up. It looks like in September of 2023, you filed a petition for an order of protection, and then on that same date, it looks like that was denied, and so that ended the case at that point. So that's the only case that I see that was on in previously, and I may be mistaken, but I'll hear from you.
Yeah, he took me to court recently. We were supposed to do mediation, but
yeah.
He needs to do at all. So.
Okay, yeah. Thank you. Thanks for pointing that out. So let me just see here where we're at. I see there was looks like there was there's a document. There's a universal trial setting calendar notice that sets the matter for today, Wednesday, April 10th at 1 p.m. To choose. Yeah, so it looks like you're a little bit early.
I'll go there.
Yeah, that's okay. It's better to be early than late. So it looks like it's via Zoom. And if you need to find the Zoom link, you can go to the Cowlitz County Superior Court website, which is cowlitzsuperiorcourt.us.
Okay, sounds good. Thank you. Sorry.
Yeah. No worries. I'm glad we get you in the right place. Okay, anybody else that was anticipating their case would be called today but was not?
Yes. So for Nicole Boaglio and Jonathan Walker.
Yes, Ms. Boaglio. Let's see. So I called the case earlier, probably maybe somewhere between 9 and 10. I'm not sure exactly when it was. When I called the case, I called for your name and asked you to respond but I didn't hear you respond, and I double checked the participant list. I didn't see you there. Mr. Zandy, who represents Mr. Walker, was present, and he asked that the matter be set over, I believe. And Madam Clerk, do you remember the date? May 14th. Okay. So we didn't address any substantive matters in the case. There was just a request to set the matter over, and I did grant the request to set it over, and we set it over to May 14th. And May 14th is a Tuesday, and I think it was at 1 o'clock, was it not?
That would work well. There's one thing, there's a slight conflict because I had someone from Chad Zandy's office. They were representing me in our divorce, so that would be a conflict.
Okay, yeah, that's as far we won't discuss that here today, but that's certainly something that you could raise in any declarations or raise at the hearing on the 14th of May. Okay, are you still there, Ms. Boaglio? Let's see, Ms. Boaglio, I see that you're still on the line, but you're unmuted, but I don't hear any audio coming from you. Okay, so hopefully, Ms. Boaglio, you got the message. May 14th, I think you got that. And then it'll be at 1 o'clock, and I think that you got that. And then the issue of any potential conflict, you can raise that on May 14th at 1 p.m. All right. With that, any other parties that felt that your case would be called but was not? All right, very good. That will conclude the hearing. I'll go ahead and sign off the Zoom, and we'll go off the record.